Welcome everyone to our webinar on refunds, returns and repairs, your business's legal obligations. My name is Kathryn and I'm a practice leader in LegalVision's commercial practice. I'm joined today by my colleague Ellie, who is also a practice leader in our commercial team. Before we begin, a couple of quick housekeeping items. You'll be emailed the webinar recording and slides at the end of the webinar. You can submit your questions in the chat box throughout the webinar and we will answer them in the short Q&A session at the end. And we would be grateful if you could please complete the survey after the webinar that will pop up. All attendees are also eligible to receive a free legal consultation with us to discuss how we can help you with your contracts or any of your other legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of the webinar. So, today we will be discussing the Consumer Guarantees Act, your obligations under it, what the guarantees actually are, what constitutes a failure to meet the guarantees, and the remedies under them, being refunds, returns and replacements, repairs, as well as some other solutions. We will then finish with a short Q&A session. I'll start by discussing what the Consumer Guarantees Act is, which we will refer to throughout this presentation as the CGA. The Consumer Guarantees Act is legislation which creates mandatory guarantees that apply where businesses supply goods or services. I'm sure many of you have heard of the CGA before, either through your experiences as a consumer yourself or from customers in relation to your business. A key concept within the CGA is that of the consumer. So, who is a consumer? A consumer is a person who acquires goods or services of a kind ordinarily acquired for personal, domestic, or household use or consumption. It does not include a person using goods or services for the purposes of resupplying them in trade, using them in a manufacturing process, or to repair other goods as part of their own business. Now that we know what a consumer is, let's look at who the CGA applies to. The CGA will apply to all businesses who sell goods or services in the course of trade. So, if as part of your business you sell goods or provide services to people for their personal use, such as clothing or electronics, the CGA will apply to you. Ellie will now talk about your obligations under the CGA.
Thanks, Kathryn, and apologies in advance. I'm just recovering from a cold, so if it's a bit croaky, yeah, I'm sorry. What actually are the consumer guarantees and what are your obligations under the CGA? The consumer guarantees are a series of rights, as Kathryn said, afforded to consumers that can't be excluded. These rights assure consumers that the goods or services that they buy will meet certain standards. Consumers' rights under the CGA can't be excluded or taken away, and they're guaranteed to a consumer no matter what. And I guess that's why they're called consumer guarantees. Your obligation under the CGA is to ensure your goods and or your services meet the standards so that a consumer is afforded those rights. Kathryn just ran through who a consumer is, so we know who is afforded these rights. But in what scenarios do these guarantees apply? An example scenario is where a person purchases a TV for their house from a store. And if the TV doesn't meet the guarantees set out in the CGA, for example, it's not of acceptable quality and it stops working within 2 months through no fault of the consumer, then the consumer can rely on the CGA to get a replacement TV or a repair or refund. Kathryn will now touch on how your obligations under the CGA may change if you're a supplier versus if you're a manufacturer of goods. Kathryn, if I manufacture pens, say, and then someone else sells them, who is liable to meet the consumer guarantees in respect of the pens?
That is a very good question, Ellie. Firstly, your obligations under the CGA may differ depending on whether you are considered a supplier or a manufacturer. But what exactly are these terms? Well, a manufacturer is a person who carries on the business of assembling, producing, or processing goods, and includes any person that holds itself out to the public as a manufacturer of those goods, any person that attaches its brand or mark to the goods, and where the goods are manufactured outside New Zealand and the foreign manufacturer of the goods does not have an ordinary place of business within New Zealand, a person that imports or distributes those goods. This is actually quite an important point because it means that under the law, if you import goods into New Zealand from an overseas manufacturer, you may actually be deemed to be the manufacturer of those goods if at the time of importation, the actual manufacturer does not have a place of business in New Zealand. So if you are acquiring goods to then distribute or resupply and trade, it is worth checking whether your overseas suppliers do have a place of business in New Zealand. Now that we know about manufacturers, let's turn to suppliers. A supplier is a person who in trade supplies goods to a consumer by transferring the ownership or the possession of the goods to the consumer, and this is done in many different ways, such as selling them to them, hire purchase, leasing, or that person supplies services to a consumer, such as a cleaning business or other repair or contracting services. Under the CGA, certain guarantees are provided by suppliers and certain guarantees are provided by manufacturers. For example, if you are a manufacturer under the CGA, you will guarantee the reasonable availability of spare parts for repairs. This does not apply to you if you are a supplier. Conversely, if you are a supplier, you will guarantee that the goods you sell are reasonably fit for purpose for which you represent that they are fit. This does not apply if you are a manufacturer. To confuse matters, however, there are also some guarantees which are provided by both manufacturers and suppliers. I will talk about this in more depth later on. The distinction between a manufacturer and a supplier can sometimes be tricky, so we advise seeking professional legal advice to determine whether you are a supplier or manufacturer under the CGA and accordingly what your obligations are. The key thing to remember here is that the CGA applies automatically in relation to the sale of goods or services, regardless of whether a business stays silent on them, seeks to limit them, or otherwise excludes them. However, there is an exception to this. If you are selling goods or services to another person in trade, such as another business, then you can contract out of the application of the CGA, provided certain conditions are met. These conditions are that the parties agree in writing to contract out of the CGA, both parties are in trade, the goods or services are supplied or acquired in trade, and it is fair and reasonable for the parties to contract out. It is usual for a contracting out provision to be found in business-to-business terms and conditions. This means that if you're a supplier of the goods, for example, you agree to contract out of the CGA in relation to the sale of those goods to another business, then the guarantees under the CGA will not apply to the supply of those goods by you to that other business. This can be a handy way to limit your liability if you're a supplier of goods or services, and is something to watch out for if you are acquiring goods and services from another business. Moving on to what the mandatory guarantees under the CGA actually are. Ellie.
Thanks. Okay, so we know the consumer guarantees apply automatically and broadly. We know that they can't be excluded and that they're likely to apply to you as a business, whether you're a supplier or a manufacturer. We also know that the consumer guarantees are the promises you are obliged to make to consumers about the quality of your goods and services. So let's break down the guarantees in a little bit more detail. If you provide goods as part of your business, you are obliged to guarantee that your goods are of acceptable quality, that they will match the description you provide to consumers, so whether it's shown in a catalogue or commercial or demonstration model that consumers may have used in store. Also that the goods are fit for the disclosed purpose and that spare parts are available for those goods, unless you have taken reasonable steps to advise consumers that spare parts aren't available for those goods in New Zealand. If you're a manufacturer and you give an express guarantee in relation to the goods, you are also required to comply with that express guarantee. That could be a warranty against defects or some other specific kind of warranty. If you're a supplier of goods, you also guarantee that the goods have a clear title, and if you are responsible for delivering the goods to consumers, that they will be delivered at the time agreed or within a reasonable time if no such time has been agreed. The guarantee of clear title means that the consumer will have the right to sell, that you have the right to sell the goods to the consumer, and that the goods do not have any undisclosed securities attached to them. An undisclosed security means that another person has some claim to the goods, such as where a financier claims to be owed money by the former owner of the goods, who may have used the goods as security for a loan. And if the consumer didn't know about the outstanding debt when they bought the goods, the supplier who sold the consumer those goods would have to provide a remedy to the consumer. For services, a supplier of services must guarantee the following: that the services are provided with reasonable care and skill, are fit for any specified purpose, are supplied within a reasonable time if no specific time is noted, and are supplied at a reasonable price if no price has been agreed. This has some sort of ancillary promises attached to it. For example, in order to fulfill the guarantees of due care and skill, any work must be completed to a standard that is at least as good as work completed by a competent person with average skills and experience for that type of work. Reasonable skill is about applying technical knowledge and know-how, and reasonable care is how much care is taken to do the job properly. Kathryn will now explain who provides the guarantees, or who provides what guarantees, rather.
Thanks, Ellie. Now, as mentioned earlier, we will look in more detail at who provides what guarantees. Whether a manufacturer or supplier is required to provide a specific consumer guarantee will depend on which guarantee was not met. As mentioned earlier, some guarantees are provided by suppliers, some by manufacturers, and some are provided by both. If a supplier has failed to meet a guarantee, a consumer should approach the supplier for a remedy. If a manufacturer has failed to meet a guarantee, a consumer should approach the manufacturer for the appropriate remedy. However, this does not always happen in practice, and often consumers will return faulty items to the store they purchased them from and will expect a remedy to be provided, regardless of whether the guarantee that has not been met was one given by the supplier or the manufacturer. In many cases, although the guarantee may have been given by the supplier under the CGA, they will still need to go back to the manufacturer for a remedy, such as a repair. If you are a supplier of goods, you should be prepared for this to happen and have clear processes in place with the manufacturer for a repair or a replacement of faulty goods so that you are able to comply with your obligations under the CGA. If a guarantee is given by both the supplier and the manufacturer, then a consumer can take action against one or both of them, provided that the consumer does not seek to recover twice in respect of the same damage. Any claims by consumers regarding goods must be made within a reasonable time, and the consumer must not have lost or destroyed the goods whilst they were in their possession. As with the guarantees mentioned above by Ellie, a reasonable time means a period of time having regard to things such as the type of goods and the manner in which they are used, so it will be quite case by case. It is also worth noting that the guarantee of acceptable quality, which is given by both manufacturers and suppliers, can be negated in respect of one party. For example, if a manufacturer has made a representation in relation to goods, other than in a statement on the packaging or the labelling, and but for this statement, the goods would have complied with the guarantee of acceptable quality, then a consumer will not have a right of redress against the supplier in this instance, only the manufacturer. On the next slide, you will see in more detail about the consumer guarantees, their remedies, and which ones apply in respect of the supplier and the manufacturer. Ellie will now touch on how you should deal with a failure to meet consumer guarantees.
When you fail to meet a consumer guarantee, you are required to offer certain solutions to consumers. Generally speaking, if you are a supplier and you have failed to meet the guarantees in respect of goods and the failure can be remedied, then the first remedy for the consumer is to have the goods repaired or replaced, or if the supplier cannot reasonably be expected to repair the goods, then by providing a refund. If the supplier doesn't remedy the failure within a reasonable time, the consumer is entitled to take the goods and have them remedied elsewhere, and then recover the cost of doing so from the supplier. If the failure is of a substantial character, then a consumer can either reject the goods subject to certain conditions or obtain damages and compensation for any reduction in value of the goods below the price paid or payable by the consumer for the goods. If a consumer exercises their right to reject the goods, then the remedy is either a replacement or a refund, and this is at the consumer's option. Note that the CGA remedies do not apply where a consumer has only had a change of mind. So even you can offer to provide change of mind returns, but you are not required to do so under the CGA. If the services do not meet the guarantees in the CGA and the failure is able to be remedied, the supplier can remedy the defect within a reasonable time, or if they fail or refuse to do so, the consumer can get a third party to remedy the defect and recover these costs from the supplier, similar to goods. If the failure is of a substantial character, the consumer can cancel the contract for services and obtain a refund or obtain damages and compensation for any reduction in value of the service or the product of a service below the amount paid or payable by the consumer for that service. What is a failure of substantial character? For goods, a major problem or failure of substantial character, it means that the product is unsafe or is significantly different from the sample or description, or that it has problems that would have stopped a person from buying the product in the first place had they known about the failure. Or otherwise, the product can't be used for its normal purpose or its express purpose. For services, a major problem would be where the services would not have been acquired by a reasonable person if they knew that the nature and extent of the failure beforehand, or if the service creates an unsafe outcome or unsafe product, or if the product of the service is substantially unfit for a purpose for which services of the type in question are commonly supplied. We will now discuss what remedies you can offer your consumers: a refund, a return, a replacement, or repair. Kathryn, tell us about refunds.
Thanks, Ellie. So under the CGA, consumers may be entitled to a refund in certain situations. A refund is where the consumer is repaid the amount they have paid for the goods or services. And as Ellie noted, a refund can be offered, for example, when a business sells a product or service with a failure of substantial character. And in this case, a business must give the consumer the choice of a refund or a replacement of the same type of product. As noted above, some businesses go beyond the requirements of the CGA and offer refunds or store credit where a consumer has changed their mind in relation to the goods they have purchased. There are some limitations here. In some cases, a refund of the price may not be sufficient, especially where the consumer has faced additional loss as a result of the defect. So let's consider this scenario. Say a consumer purchases a new desk for their office. They set up the desk in accordance with the instruction manual and they place their computer on the desk. The desk then breaks and the computer falls and the screen is damaged. In this situation, the consumer will likely be entitled to a refund for the price of the desk, but may also be entitled to consequential losses, such as recovering the price for having their computer screen repaired. In addition to refunds, consumers also have the right to a return or a replacement, which Ellie will now go through with you.
So the remedy of a return and replacement primarily relates to the provision of goods where a consumer may choose to bring back a faulty good. A return of a good is closely linked to a refund or replacement, as it's not often that we would bring back clothes that are faulty or damaged and only want to return them without getting our money back or getting a replacement. Consumers can choose to return goods and ask for a refund, or return goods and ask for an identical replacement. However, as we discussed earlier, if the failure is not of a substantial character, the supplier can ultimately choose whether to repair the goods, provide a replacement, or refund the consumer. A replacement must be of an identical type to the goods returned. And if that is not possible, then you, the supplier, can offer something of the same type and similar value. Otherwise, the consumer can choose a repair or a refund instead. The consumer has the obligation to return the goods to you unless it cannot be done without significant cost to them, in which case you must collect the goods from the consumer at your cost and within a reasonable time. An example would be if a consumer buys a large fridge and due to a major fault, they want to return it and get a replacement fridge. The supplier in this situation would likely need to collect the fridge from the consumer within a reasonable period of time and then provide a replacement. It's important to note that the same consumer guarantees will apply to the replacement fridge as they did to the original faulty fridge. Okay, so we've spoken about refunds, returns, and replacements. Kathryn will now speak about repairs.
So a repair is another remedy available to consumers under the Consumer Guarantees Act, and it is most appropriate when the failure of the goods is not substantial and they can be repaired within a reasonable time. In this case, the consumer can require the supplier or the manufacturer, depending on the circumstances, to repair the goods. The goods must be repaired within a reasonable time, and again, what is reasonable will depend on the circumstances. As an example, if a consumer is having issues with an essential household item, such as a kettle, which is used most days or several times a day, the business will be required to repair this quicker than something that is not as essential, for example, a lawnmower, which may be used every few weeks. Where a kettle cannot be fixed within a reasonable time, the consumer will be entitled to another remedy in this example, for example, a replacement or a refund, but the same reasonableness standard will apply to any of the goods that are being repaired. It is also worth noting that if a consumer cannot get the goods repaired within a reasonable time and they have to take them elsewhere for repair, then they can recover the cost of that repair from the original supplier. So normally and they can recover the reasonable cost here too. So again, what is considered reasonable will be determined on a case-by-case basis, having regard to the goods, the manner in which they're used, how long it took for the original supplier to fail to complete the repair, and can be, I guess, a subject of a dispute between the parties. Ali will now look at other solutions for repairing or refunding things under the Consumer Guarantees Act.
Thanks, Kathryn. Actually, something Kathryn mentioned earlier in relation to her desk example were these consequential losses. So in addition to providing a refund, repair, or replacement, a consumer may be entitled to recover compensation for loss or damage to the consumer resulting from the failure to meet the guarantees. The loss or damage must have been reasonably foreseeable and not caused by something outside of human control. So another example would be if a consumer hired a trader to build a deck onto his house, the deck was not properly constructed and collapsed, injuring the consumer and causing damage to his outdoor furniture. The consumer may in this situation be entitled to compensation for his medical expenses and the repair or replacement of his outdoor furniture, in addition to a refund for the cost of the deck. If you're a manufacturer and your goods or services fail to meet the applicable guarantees, you will be required to remedy that failure by way of compensation for damages. So you may be required to pay a consumer damages for any reduction in the value of the goods resulting from the failure and for any loss or damage to the consumer resulting from the failure, which was reasonably foreseeable. However, if you're a manufacturer and you provide an express manufacturer's guarantee, this might be different, because if you provide an express manufacturer's guarantee, you can stipulate that the remedy for a failure or a defect is a repair or a replacement. A further solution exists where a consumer is returning a good and there is a linked service contract. Where goods are connected to a service contract, such as where they order a good and the supplier offers to install it or maintain the good over time, so provide servicing to the good. The consumer may also cancel the linked service contract. And they can do this when they're returning the goods or within a reasonable time after the return without incurring any penalty. If a consumer cancels a linked service contract for unsatisfactory services, they must return any goods connected with those services, even if there's no problem with the goods. If they've paid any money for the goods, you must provide a refund, and consumers are ultimately responsible for returning the goods, unless, of course, it would involve significant cost to them, as I mentioned earlier. Cancellation takes effect when a consumer notifies the supplier that they want to cancel. So you can see that the consumer guarantees are quite broad and they apply in many situations. It's best to be across your obligations and potential solutions to ensure that you can comply with your obligations under the Act. If you refuse or you're not prepared to offer solutions to consumers where you have failed to meet your consumer guarantees, the consumer can take you to the disputes tribunal or court. That concludes the main part of our webinar. You might find our publication useful, New Zealand Startup Manual, Legal Handbook for Founders, and you can access this by accessing the handout section in your webinar panel. We also have a webinar coming up that might be of interest to you, Corporate Governance 101, and that's on Tuesday, 9th of May at 12 p.m. New Zealand time. You can register at the link below. We're going to answer your questions shortly, but while you submit them, we'll take a minute to tell you about our membership. Kathryn will walk us through it now.
LegalVision's membership is a cost-effective alternative to the expensive hourly rates you often experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document reviews, drafting, amendments, business contracts, and commercial leases. It includes unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment disputes, and more, and unlimited domestic trademark registration. Our membership is like having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how the membership can help you, please request a free consultation when the survey appears at the end of this webinar. We'll now answer some of your questions.
So we've got one here that says, when you say claim for goods within a reasonable time, is that legally defined in New Zealand and Australia? Now, it's not sort of specific timeframes provided in legislation, but there's guidance, and Kathryn touched on this earlier. So a reasonable time means a period of time having regard to things such as the type of goods and the manner in which they're used. So there's nothing specific per se, but it's taking in consideration the goods themselves. I don't know if you have a good example, Kathryn, off the top of your head. If I think of one, I'll let you know.
No, I don't have one off the top of my head. I think quite often you would see people would have an argument about the meaning of what's reasonable in the context.
Totally.
And in my experience, generally, the supplier ends up just going with what the consumer wants because there's value in retaining business reputation for providing timely remedies. So another question that we've had through here is, as an online travel agency, we sell tickets on our website. We would like to understand more about our obligations by law. So this is actually a very complex question because there is an overlay of, for example, the Civil Aviation Act, which applies to airline tickets. So just from a very high level, as the travel agency, you will be required to comply with the service guarantees in the Consumer Guarantees Act, such as that your services are fit for purpose and that they're of an acceptable quality. In terms of the airline tickets, that will actually be a contract between the airline and the passenger themselves, which will then have that overlay of Consumer Guarantees Law, other Fair Trading Act laws, and also the Civil Aviation Act. But we can provide you with further information on this in a free consultation.
We've also got one here that says, if a consumer purchases a product online from an overseas supplier, what rights do they have if there's a fault with the product? It's a bit of a tricky question because if an overseas business has a place of business in New Zealand, then the CGA will apply to them. However, if they don't have a place of business in New Zealand, then it can be more difficult to obtain a remedy, and it may depend on the consumer laws in the country that the supplier is operating from, and the help that consumer protection agencies can provide is limited in this situation. it is something as a consumer to be aware of when you're purchasing goods from overseas, and it is worth doing some homework on the trustworthiness of the business, looking at reviews by other consumers, as well as refunds, as well as any refund or return policies on their website before you commit.
Another question we've got here is, are there circumstances when the consumer guarantees won't apply? Yes, there are. So they won't apply for private sales, such as on Facebook Marketplace or Trade Me, unless the seller is in trade. And the guarantees also don't apply where you have business-to-business transactions and the Consumer Guarantees Act has been expressly contracted out of, as I discussed earlier on in the presentation.
Also got an interesting one here around if a customer bought a custom product and it was made in the time frame as stated on the website and sent out to them, but the delivery of the product was delayed due to New Zealand Post or postal services misplacing the product. Now the customer wants a refund and is claiming loss of income due to delay, but is also keeping the product. Look, this is a pretty complex and big question. Ultimately, the arrangement or the contract is between you and the customer for the delivery of those goods, and therefore, it's as between you to provide any remedies to the consumer in that situation if the consumer guarantees haven't been met. However, I suppose there are ways around this in terms of whether you have any agreements with New Zealand Post or delivery services, things like that. That's often one way that people have contracts in place to ensure that there's some coverage for that. But yeah, it's a bit of a tricky one. But ultimately, yeah, you have the obligation to the consumer.
I think it would also be worth looking at what your insurance covers in that situation
Totally.
as well. And whether they could claim a refund for a delay in delivery would also, I guess, depend on whether that's considered a failure of substantial character.
And that would depend, I suppose, on what you'd what you'd said in terms of when the product was going to be delivered, and if there was any room in your contract with your customer around, there might be delays outside of our control, that kind of thing.
Yes, exactly. We have another question here. What guidance do we have for the definition of in trade? So in trade is defined in the Consumer Guarantees Act, and it is a very broad definition. I can't recall the exact wording off the top of my head, but it does include basically any business activity, any activity for commerce or obtaining revenue. So obviously there are other exclusions where if you're selling something privately on Trade Me, that's not in trade because it is essentially a one-off, but in trade would be where that is your business, that is what you're making an income from, and it's your usual course of practice.
Okay, if I am a supplier, do I have to provide a replacement, repair, or refund to consumers if the goods are faulty as a result of the manufacturer's failure to comply with the consumer guarantees? Yes, as a supplier of goods in New Zealand, you do have that responsibility to ensure that the goods you supply comply with the consumer guarantees provided under the Act. As discussed under the CGA, consumers have a right to expect that the goods that they purchase will be of acceptable quality and fit for purpose. And as a supplier, it's your responsibility to ensure that the goods do meet those requirements. Regardless of whether the failure is due to a fault of the manufacturer or the supplier, the consumer is entitled to a remedy. However, if you're the supplier, you might be able to seek compensation from the manufacturer for any costs that you incur as a result of their failure to comply with the consumer guarantees. But ultimately, this doesn't absolve you of your responsibilities and obligations under the Act.
So we've got one here about a website for keeping track of Pokemon cards. So like Trade Me, but not charging money, and where I guess the Consumer Guarantees Act would apply in that sort of marketplace situation. So if all you're doing is providing a platform where people can make listings and sell them to other persons, then you would be liable under the Consumer Guarantees Act for the services that you're providing through that platform. And it would be very worthwhile having some terms and conditions which outline very clearly that if people sign up to use the platform, then any sale and purchase arrangements made through the platform are between them and have nothing to do with you. And you are simply just the facilitator of that platform where people can sell those cards.
So is it mandatory to keep spare parts for special made or custom made products? Or should the customer keep it in stock? In other words, should spare parts be readily available in stock, or can it be manufactured when needed? So unless you have made a clear statement to a consumer that spare parts won't be available for this product, and that's a consumer knows that before they purchase the product, then yes, you do have an obligation to provide repairs and spare parts. That's one of the consumer guarantees. Now, whether or not you have to have them readily available or they can be manufactured when needed will probably depend on how quickly you can manufacture them, because again, it comes down to this reasonable time, what the specific good is, potentially if you can manufacture the spare part within a short time frame, that would be acceptable. But if a consumer has to wait for several months to get their spare parts, then that probably wouldn't be acceptable. Again, it's very subject to what the specific good is in that circumstance.
So we've got, how liable is an online marketplace such as Airbnb for refunds? This will depend on, I guess, the terms on which you have either signed up to as a person renting an Airbnb or as a person listing the Airbnb. But I would think that it would be the owner of the property, if they have taken payment, it would be on them to repay any refunds, but it will also depend on the cancellation policy and policy within the Airbnb's terms and conditions, as well as whether, I guess, the owner is considered to be in trade, which I think if you're running an Airbnb as part of your business, you would be. So again, a little bit fact dependent and terms dependent, but generally the person who's providing the goods or services, if they're a failure of substantial character, and depending on the other commercial terms, it will be the Airbnb owner who's taken payment.
We've also got a question here. When a product becomes obsolete, what should a manufacturer do to support these old products in the field? Again, this is kind of context specific and product specific. As we discussed in the presentation, the consumer guarantees in respect of a product will only apply for what is considered a reasonable period of time. So, for certain goods, 5 years after purchase, fair wear and tear could mean that those products no longer work as well as they originally worked when the consumer purchased them. And if at that point in time the product's becoming obsolete, the manufacturer is no longer making them and they're not being supplied in New Zealand, unless there's a express guarantee that said, we'll repair and replace these goods for 5 years or 10 years, then you might not be required to, you might not be failing to meet your consumer guarantees. If, however, it's within a shorter period of time, or it's a product that you would expect reasonably to last 5 years, then in this situation, because it's the manufacturer, if you have servicing facilities, then you can obviously do that, or your obligation as a manufacturer in respect of the consumer guarantees is to provide compensation. So if the good isn't meeting the consumer guarantees and you haven't provided an express warranty for defects against defects, then you'll be required to compensate the consumer. Hopefully that answered that question. You got any more? Can't see any more on my end, Kathryn.
No, I think that's all that has come through for now.
Okay. Well, that's probably all we have time for today. Anyway, after the webinar ends, you will have a survey pop up, and we'd be really grateful if you could complete the 30-second survey. Please include your details to receive a complimentary legal consultation to discuss how we can help you with complying with your obligations under the Consumer Guarantees Act. Thank you all so much for joining us today. We hope you learned something, and thanks for joining.
Yes, thank you very much.